are invariably thoughtful and fair. Ms. Blatt, who clerked for and is an ardent admirer of Justice Ginsburg, and who is, in her own words, an unapologetic defender of a woman's right to choose, says that Judge Kavanaugh fits within the mainstream of legal thought. She also observed that Judge Kavanaugh is remarkably committed to promoting women in the legal profession. That Judge Kavanaugh is more of a centrist than some of his critics maintain is reflected in the fact that he and Chief Judge Merrick Garland voted the same way in 93% of the cases that they heard together. Indeed, Chief Judge Garland joined in more than 96% of the majority opinions authored by Judge Kavanaugh, dissenting only once. Despite all this, after weeks of reviewing Judge Kavanaugh's record and listening to 32 hours of his testimony, the Senate's advice and consent roll was thrown into a tailspin following the allegations of sexual assault by Professor Christine Blasey Ford. The confirmation process now involves evaluating whether or not Judge Kavanaugh committed sexual assault and lied about it to the Judiciary Committee. Some argue that because this is a lifetime appointment to our highest court, the public interest requires that doubts be resolved against the nominee. Others see the public interest as embodied in our long-established tradition of affording to those accused of misconduct a presumption of innocence. In cases in which the facts are unclear, they would argue that the question should be resolved in favor of the nominee. Mr. President, I understand both viewpoints. This debate is complicated further by the fact that the Senate confirmation process is not a trial. But certain fundamental legal principles about due process, the presumption of innocence, and fairness do bear on my thinking, and I cannot abandon them. In evaluating any given claim of misconduct, we will be ill-served in the long run if we abandon the presumption of innocence and fairness, tempting though it may be. We must always remember that it is when passions are most inflamed that fairness is most in jeopardy. The presumption of innocence is relevant to the advice and consent function when an accusation departs from a nominee's otherwise exemplary record. I worry that departing from this presumption could lead to a lack of public faith in the judiciary and would be hugely damaging to the confirmation process moving forward. Some of the allegations levied against Judge Kavanaugh illustrate why the presumption of innocence is so important. I am thinking in particular not of the allegations raised by Professor Ford, but of the allegation that when he was a teenager, Judge Kavanaugh drugged multiple girls and used their weakened state to facilitate gang rape. This outlandish allegation was put forth without any credible supporting evidence and simply parroted public statements of others. That such an allegation can find its way into the Supreme Court confirmation process is a stark reminder about why the presumption of innocence is so ingrained in our American consciousness. Mr. President, I listened carefully to Christine Blasey Ford's testimony before the Judiciary Committee. I found her testimony to be sincere, painful, and compelling. I believe that she is a survivor of a sexual assault and that this trauma has upended her life. Nevertheless, the 4 witnesses she named could not corroborate any of the events of that evening gathering where she says the assault occurred. None of the individuals Professor Ford says were at the party has any recollection at all of that night. Judge Kavanaugh forcefully denied the allegations under penalty of perjury. Mark Judge denied under penalty of felony that he had witnessed an assault. P.J. Smith, another person allegedly at the party, denied that he was there under penalty of felony. Professor Ford's lifelong friend, Leland Kaiser, indicated that under penalty of felony, she does not remember that party. And Ms. Kaiser went further. She indicated that not only does she not remember a night like that, but also that she does not even know Brett Kavanaugh. In addition to the lack of corroborating evidence, we also learned some facts that raise more questions. For instance, since these allegations have become public, Professor Ford testified that not a single person has contacted her to say, I was at the party that night. Furthermore, the professor testified that although she does not remember how she got home that evening, she knew that because of the distance, she would have needed a ride. Yet not a single person has come forward to say that they were the one who drove her home or were in the car with her that night. And Professor Ford also indicated that even though she left that small gathering of 6 or so people abruptly and without saying goodbye and distraught, none of them called her the next day or ever to ask why she left. Is she okay? Not even her closest friend, Ms. Kaiser. Mr. President, the Constitution does not provide guidance on how we are supposed to evaluate these competing claims. It leaves that decision up to each senator. This is not a criminal trial, and I do not believe that the claims such as these need to be proved beyond a reasonable doubt. Nevertheless, fairness would dictate that the claims at least should meet a threshold of more likely than not as our standard. The facts presented do not mean that Professor Ford was not sexually assaulted that night or at some other time, but they do lead me to conclude that the allegations failed to meet the more likely than not standard.